in all this planning, we seem to have we have this baseline assumption that I'm, able to come sit down with you, rationalize these choices and execute these documents. What happens if either I'm mentally incapacitated, or we start this process and somewhere along the way become mentally incapacitated? A critical part of any estate plan, obviously, is a durable power of attorney. How do they fit into all this, though? And what are the drawbacks to sort of not keeping an eye on that and having a bad one?
I love this question because I tell people, of all the fancy planning and trust that I put together, this absolutely, without a doubt, the single most important document that I do is a well-drafted, enhanced, durable power of attorney, bar none. And the reason is, if my client becomes incapacitated and they have not planned with a good power of attorney in advance, then we are hamstrung. And now, instead of relying on a power of attorney, we now have to go through the guardianship process, which is a lot more time consuming and expensive. We have to be careful, though, with powers of attorney, because they're not all created equally. I think some people have the sense that you can just download a document that's free, and there's lots of free powers of attorney on the internet, right? You can download free power of attorney, and it's funny, I did a separate video which I'll send you later, basically looking at the 3 most common free forms that I see floating around the internet. And they have serious problems because there's a few reasons. Number one, there are a lot of old forms that are pre-2011 that are around the internet. And there are lots of attorneys who are still printing out these forms because they're not estate planning attorneys. They're just, I call them door law attorneys. Whatever walks in the door, they'll take. And there's using these old forms that don't comply with 2011 requirements. And I think people think that you could just sign a document that says, I, Mr. Smith, give my son and daughter, Joe and Susan, the ability to make all decisions for me, no matter what, so help me God, and that's it. And then they sign it and they think that's okay. Well, that's not how these documents work. These documents are very specific. And in fact, if what you're trying to do is not specifically listed in the document, then you can't do it. Your agent can't do it, right? So that's the big problem with these generic forms that we see floating around the internet. Not only that, there are certain provisions where you can be as crystal clear as you want, such as creating revocable and irrevocable trust, which is, we're doing a lot of that in Medicaid planning. And if they're not properly spelled out and initialed, not only signed, but and initialed right next to it, you also can't do it. So this is a problem I have with people who, I say, please don't cheap out on the power of attorney. Don't download the free form. There are forms, by the way, that I tell people you can download for free. You'll probably be fine with. The Florida Bar has a free Florida healthcare surrogate statute form, a healthcare surrogate designation form, so who can make healthcare decisions for you. That's going to be fine 99% of the time. I happen to like my form better because I make it a lot more detailed, but it's not strictly needed, and I just like things to be clear and put in a way that I think is going to make my client's life easier. But some of those free forms are fine. Don't mess around with the free form, though, when it comes to a durable power of attorney.